Okay, welcome to the video. So this is the fourth episode in our investigation of legal philosophy, and today I'm going to talk about why I'm not a fan of mainstream jurisprudence, what I think is wrong with mainstream jurisprudence. Now, actually, before I start talking about this, let me just say something about this series and the channel. So this stuff that we're talking about is hard, right? It's not easy, and it's quite likely that as you watch this, you'll have some questions about it, things that you don't understand, or things that you think are wrong, or anyway, things that you'd like to ask about. Anyway, if that happens, I'd be delighted if you put the question in the comments. And what I'll do is, well, I might just respond to the comment, but I might actually make a new video responding to questions. And I'd really like to do that for a number of reasons. One is that it would help grow the channel, because one of the main indicators of the success of a channel, or the algorithm's much more likely to push out channels that receive comments on them. I recently discovered the other day I was getting a bit down about the fact that the channel's not growing as I might have hoped. And I watched some YouTube videos about this, and they say you can forget about growing your channel until you've got about 100 videos out, which is a little bit disconcerting, because I don't know that I've got the patience for 100 videos, especially 100 videos like this. I mean, 100 videos about cute cats is one thing. 100 videos about philosophical issues or legal issues is something else. But we'll see. We'll see how we go. But anyway, any comment you make would be very helpful, and certainly, please, if you've got questions, I'd love to hear them. And as I say, I'll make videos in response to them. So that might be very beneficial for all of us. Anyway, what's wrong with mainstream jurisprudence? Okay, now another little preface here is I want to make it clear when I do this that I'm not saying that the people who do mainstream jurisprudence are a bunch of morons or anything like that, right? I don't believe that they are. I think, generally speaking, actually, the people who do jurisprudence, tend to be if I can put it this way, the more intelligent people within a law school, right? I think that's fair to say, right? I don't know, but that's been my experience. And I don't mean, if you're not doing jurisprudence, you're a moron either, right? I just mean, there's a tendency that the smartest people do this kind of thing. Not always, but there's a tendency. So I'm definitely not saying that they're all a bunch of muppets. I think something's gone wrong with the discipline, and we need to find our way out of this problem. And I intend the rest of the course as a way of finding our way out of this problem. Now, what's the problem? Now, in the book I wrote upon which this series is based, I mentioned three things. I claim that modern jurisprudence is insular, archaic, and incestuous. Now, I won't go through all of that, but I just want to give you the flavour of the criticism now. If you pick up a textbook on the philosophy of law, what you find is that the textbook tends to be organised not so much around ideas or parts of the law or aspects of the law that, people might be ordinarily interested in, but rather around schools of thought within mainstream jurisprudence. So, for example, let me just contrast this. If you pick up a textbook, there aren't that many, right, but there are some, in the philosophy of music, you'll find that the textbook organised, or philosophy of art, say, you'll find the textbook organised around interesting questions about art and our responses to it. Like, for example, questions like, well, if music is just a non-sentient thing, I mean, it's a thing that doesn't have any feelings, how can it be happy or sad, right? So a question like that, why are we interested in it anyway, if it's just a bunch of sounds? How is it possible for painting, which is two-dimensional, or basically two-dimensional, to represent three-dimensional images? Questions like this, it looks as if in the philosophy of art, we're asking questions about art, right? And our responses to art. Whereas in the philosophy of law, it doesn't really look like that at all. Right? When you pick up a textbook, it's not like, here are some interesting questions about law. It's not that at all. It's like, who's right, Hart or Dworkin? Right? It's the questions like that. In fact, this is often referred to as the Hart-Dworkin debate, right? And there are introductory textbooks or introductory books in law that are even called things like The Great Debates in Jurisprudence. In fact, there is a book called that, written by very good authors, by the way. That book is written by very good people. But notice the focus. The focus is on not law, but jurisprudence. That is, the focus of the philosophy of law is the philosophy of law, right? And I think this is a sign of a discipline in crisis. The philosophy of law has become about the philosophy of law rather than about the law itself. Not completely, but more than is healthy in a discipline. So the discipline is organised around schools of thought, and one area in which this is so that we've already seen is in its approach to classical positivism. So, I started the course with classical. I mean, I did a little bit of an intro, and then I talked about classical positivism, and I said when I introduced that theory that almost nobody thinks the theory is true anymore. Now, you might have asked yourself then, if nobody thinks the theory is true anymore, why the hell did I teach it? No, I think that's a really good question. Right now, the answer, why did I teach it, is because that's how everybody else teaches the subject. And the point of what I was doing was I was giving you a sort of primer in mainstream jurisprudence. That's why I did it. But I think it's weird too, right? I mean, if everyone thinks the theory is false, why do you have to teach it at all? Why don't you just go on to the stuff that could be true, right? Why don't you just start with modern positivism? Okay, and the answer, there's two answers, and I think they're both bad answers, right? One answer is because the philosophy of law is about the philosophy of law, right? And classical positivism was an important movement in the philosophy of law, so we teach you about it. Right, the fact that we all agree that it's wrong doesn't change anything, right? But it should change something, right? If we think it's wrong, we need to move on, right? So that's one answer, and I think it's a bad answer. The other answer is, in a way, it's more scandalous, even more scandalous. I think we teach classical positivism because if we didn't, we wouldn't think that modern positivism was very interesting. Okay, and now what were the two really key claims of modern positivism? They were that law can be immoral. We didn't focus on this too much, but we did introduce the idea that law can be immoral. There's a distinction between the way the law is and the way that it should be, right? And that law is a system of rules. These were the two big ideas. Now, what I want to ask you is, what I want you to ask yourself, are those really big ideas? Right? Are they really profound ideas? Right? If I'd just come up to you on the street and said, hey, do you know that law is a system of rules? Right? Would that have amazed you? Right? Would you have thought, wow, this guy's deep? Right? Or would you have thought, mate, that's so obvious, it's not worth talking about? I think you would have said it was so obvious it's not worth talking about. Now, we did see along the way that there was, that there was a genuine discovery here. I'm not saying that it wasn't a discovery. It was there was importance there, but it's not really profound, right? It's not a very deep discovery. And the idea that law can be immoral, well, we all knew that, right? There's no great discovery there, right? We all knew that. Right, so what I'm saying here is part of the reason that we teach classical positivism, and this is the scandal here, we have to every year we have to convince students to entertain a view that's false, so they think that the true view, or at least the more true view, is interesting and profound. Because otherwise, if we just taught the modern view straight off, people would think, what's all the fuss about? But the truth is, what is all the fuss about? I just don't think modern positivism is a very interesting theory. I'm not saying it's false. I'm just saying it's not very interesting. Now, again, I need to say something about Hart here. I'm not saying that Hart didn't do anything important, because pointing out falsehoods is a very important thing to do, right? And if everybody believes a falsehood, or nearly everybody believes a falsehood, noticing that it's false can take, it can be quite an achievement. And in Hart's case, it was an achievement, although I think he nicked a lot of it from Kelson, but that's another matter, right? But so noticing a falsehood can be a real achievement, but it doesn't mean the new theory is profound or interesting, right? It's just getting rid of a mistake. Right? This is why, as I said in the last video, we need to learn from Hart. Yeah, Hart made a contribution, but we need to move on. The idea that law is a system of rules and that law can be immoral, those ideas are both, I think, true, but not that interesting. Right? Certainly not worth a whole course on. Right? Some universities, it's compulsory to study this stuff. Some law schools, it's compulsory to study this stuff. This is not that important. These ideas are not that important. Right? I'm not saying the philosophy of law isn't important, or at least it could be important if it was done properly, but it's not being done properly. Right? These ideas are not important. Right? They're not false, but they're not important. Okay, all right. So that's part of my beef with modern jurisprudence. I think it's not that it's wrong or anything. It's just that it sets itself up as this profound discovery of this deep inner truth about the nature of law. And I don't think it's anything of the sort. I think it's a discovery. It's something that's true. It's something that's significant. But it's not that big a deal, right? It's not that interesting. Now, the natural lawyers that we just touched on last time, I think they have profound and interesting ideas. But legal positivism itself just strikes me as pretty trivial. Not that interesting, right? And something that we should learn from but move on from, right? That's what we need to do. And as I said last time, that's really my beef with Hart. Not that he's wrong or anything, although I think he's wrong about some things, but as we'll discover later on in the course. But that's not the real problem. It's that, yeah, he made some discoveries, but, we need to move on from them. And the problem, which is not his problem, it's our problem, is that we seem unable to move on from him. We keep treating him as some kind of demigod of the discipline, and we can't just sort of say, well, it's time to move on from this now. Learn from him, but move on. Okay, so that's the sort of insular, archaic, and incestuous stuff that's from the book. That's that criticism. But I have another criticism that I didn't actually make in the book explicitly, but I should have. I do talk about this in the book, but I didn't make it explicitly as a criticism of modern jurisprudence, and I should have. And that is a slogan for capturing this criticism is to say that modern jurisprudence just takes the law for granted. That's what I want to say. That's what I should have said in the book. Modern jurisprudence just takes the law for granted. And so in that sense, it isn't really providing a philosophy of law, because the job of the philosophy of law is to conduct a philosophical investigation of law, not to simply take law for granted. If you're taking law for granted, you're not doing philosophy of law. Now, what do I mean by taking law for granted? I think a really good example of what I'm talking about is in Hart's criticism, can be found in Hart's criticism of natural law. And I mentioned this in an earlier episode too. When criticising natural law, one of the things that Hart says is, look, the natural lawyers think there must be an essential connection between law and morality. There must be an essential connection between law and morality. And Hart says, no, that must be false, because we know that there exist laws that are immoral. And he gives some examples. So laws of Nazi Germany, laws of apartheid South Africa, the Jim Crow laws in the south of the United States that enforce segregation, and so on. So he just points to these laws. He points to these laws and says, look, these laws are immoral, so we can see that there isn't an essential connection between law and morality. Now, what do I want to say about that? What I want to say about that is that just takes the law for granted, right? It just says, look, there are these laws. How did he do that? Right, he just said, there are these laws. How did he do that? Now, this might strike you as a really weird issue that I'm raising, but to think that there is an issue here is the start of being a philosopher. That you can't just point at something and say, look, there it is. I mean, the person who really brought this point out was a philosopher called Ludwig Wittgenstein. Okay, which is the way that Wittgenstein made the point would be to say, now it's going to be very hard to do this here because I haven't got quite the scale, but let me just, okay, I'll just hold this cup up, right? And let me say, I point to the cup, okay, and I say, okay, I'm talking about this. I'm talking about this. And here I am pointing at the cup. Now, what Wittgenstein pointed out is that this doesn't really solve anything. So if there's some dispute about what I'm talking about, and I say, I'm talking about this, it doesn't really solve anything because while I could be talking about the cup, I might be talking about other things. Like, for example, I could be talking about the wall, right? That's over here. The wall that's over here on the other side of the cup. Or I could be talking about the air, right? That's between my finger and the cup. Or I could be talking about the colour of the cup. Or I could be talking about, so hold up the cup again. I could be talking about one of the circles on the cup, or I could be talking about the colour of one of the circles on the cup, or I could be talking about the material out of which the cup is made, right, rather than the cup itself. Or I could be talking about the contents of the cup. Imagine it's full of coffee. I could be talking about coffee. It's actually got a tea bag in. I could be talking about, this is dried up old tea bag. I could be talking about the tea bag, right? So the pointing raises the philosophical issue. It doesn't solve the philosophical issue. That's the point that Wittgenstein makes. And Hart, who is supposed to be, people will tell you that he was, completely boned up on all this kind of philosophy because he was sort of in the next generation of philosophers after people like the John Austin, the new John Austin, not the old John Austin, who was one of Hart's teachers, and Wittgenstein and so on. They were around at the time. Hart was aware of all of this, but he seems to me to not have been actually, or not have to understood the significance of these theories. So Hart just points to some laws and says these laws are immoral, right? But there's a whole bunch of philosophical questions there that he's just overlooking. And that's what I mean by taking the law for granted. For example, are those laws? Why are they laws? How can they be laws? How do we know that they are laws? Right? And how do they function as laws? There's all these philosophical questions that we can ask about them. And in particular, in the context that he's raising the question, there are questions such, or raising the examples, there are questions such as, are they really laws? Or do they just look like laws? Or are they completely laws? Are they fully laws? Or are they kind of just half laws? Are they just a little bit laws, but not fully laws? These are philosophical questions that we have to ask that you can't solve just by pointing, right? But that's what Hart does. John Finnis has made this point about he hasn't put it quite this way, but he makes this point about the pointing argument. He says, look, I'm not denying that in one sense these things are laws, but in another sense they aren't laws. Now, Finnis may be right or wrong about that, but the point is there's a philosophical issue here, and Hart thinks that he can overlook that philosophical issue just by pointing. That is just to take the law for granted. Right? And I think this is a big problem with mainstream jurisprudence. It just takes the law for granted. Let me give you another example of this. In fact, we've seen this. This problem has been discussed before. So Hart's great discovery, it's really Kelson's discovery, is that law is, to use our language, a matter of deontic power. It contains deontic power. It's about rights, duties, powers, permissions, and all of that stuff. Okay, but how? Right? How does law get that deontic power? There's a really interesting philosophical question here. That's in fact what I'm going to try and explain in the I'm going to start trying to explain that in the next episode, although it's going to take me some time to get there. But that's for me, that's the central question, or at least a central question in the philosophy of law. How does law gain that power? It has no explanation for that. Okay, here are some other interesting questions about law that we should be asking but aren't asking. What is it about human beings that makes us able to create law? See, there are lots of other clever animals on this planet, right? Chimpanzees, bonobos, dolphins, right? And they have pretty complex societies, right? I mean, if you see, I recently watched this amazing documentary on chimpanzees about the complexity of the societies in which they live and the conflicts between the societies. Are very complex creatures indeed, but they don't have law, right? They're very clever, but they don't have, very complex, but they don't have law. Okay, so we've got something that they don't have, not just law, of course, but there's something about us that makes us capable of having law that chimpanzees and gorillas and bonobos and dolphins and so forth don't have. What? What is that? Well, this is a question that we should be asking, right? That mainstream jurisprudence just doesn't ask. And there are a bunch of other questions like this. Let me give you now a concrete example of a law. So here's a slide. This is just a section from New Zealand's Crimes Act, 1961, so I did get the date right last time. So just to read a little bit of this. Theft or stealing is the act of dishonesty and without claim of right, taking any property with intent to deprive any owner permanently of that property, of any interest in that property, or blah, blah, blah. Okay, so we don't need to read all of that. But the point I want to make about that is this. There's a kind of magic, right, in this act and in other laws. The magic is that someone just writes this down. It's not just writes it down. There's a bit more complex story than that. But basically, someone just writes this down, and then it becomes law. How does that happen? Now, you might think when I ask the question, how does that happen? I'm asking you a technical question about what's the process in my jurisdiction for making something law. But that's not what I'm asking. That's an interesting question. Well, it's sort of interesting. It's more interesting if you're a public lawyer. I'm not one. I don't really care about stuff like that. But there's some interest in that question, right? What's the actual process of going about making a statute? But that's not the question I'm asking. The question I'm asking is different. The question I'm asking is this. Basically, someone writes this down and then a whole lot of people start obeying it. Why? Why does that happen? Right? Someone writes it down, people start obeying it and enforcing it. Why? Why does that happen? What is it about us? What is it about us human beings that makes us like that? Some people write these things down, some people sign it, and then we all start obeying it and some people start enforcing it. Why do we do that? What is it about us that makes us the kind of creatures that behave that way? There's nothing about this in mainstream jurisprudence. It's just not a question that they ask. This is why I say mainstream jurisprudence takes the law for granted. Think also about the lockdowns if you're in a country that experienced them. Now, I'm not here talking about whether they're a good idea or a bad idea or getting into the politics of the lockdowns, but let me just tell you a story, the story about what happened in this country. So one day, I think it was a Monday, but it may have been a Tuesday, a rather frail, slender young woman came on television and said that from the Thursday onwards, people would not be allowed to go outside their houses except for with certain conditions, but people were not going to be allowed to go outside their houses, but there was going to be a lockdown. Now, that slender young woman happened to be the Prime Minister of New Zealand, Jacinda Ardern was her name. And the amazing thing was, and we ought to be amazed by this, when Thursday came around, people stayed home, right, in their houses and did not go out. Now, the reason I'm stressing the fact that she was a slender young woman is the fact is she could not have herself, the person who appeared on that television program could not herself have stopped me from going out of my house. Right, I mean, I'm getting on these days, right? I'm not, but if it was a matter of physically stopping me getting out of the house, she could not have stopped. Even now, in my 50s, getting on, but even if she's a slender, she could not have stopped me getting out of the house, and yet I obeyed her. Why did I do that? Why did I obey her? Now, you might come up with the kinds of answers that my students generally come up with in this context. You might say things like, "Oh, I'm worried that I was going to get caught by the police and prosecuted," or I was worried about getting COVID and I didn't want to get sick." None of that strikes me as right. They may be also reasons that I had, but the fact is that I obeyed her because she said it. Why? She doesn't have the physical power to do anything to me. Now, you might say indirectly she does, because she can get the police to arrest me, and they do have the physical power to coerce me to do things. But notice that just raises the question again. Why does she have that power over those people? Right? She's just a person. Right? Why does she have that power? There's nothing like this in chimpanzee society. In chimpanzee society, you have to obey the alpha male, but that's because the alpha male might beat you up if you don't, right? There's nothing like that, right? When Ardern went on television and said, you have to stay home. I didn't stay home because I was worried that Ardern was going to come around to my house and beat me up. No, chimpanzee society is rather more complex. It's not just the alpha male. There's the alpha male, and they have allies and so forth. They're sort of a gang that supports the authority of the alpha male. But none of that's true about what happened in New Zealand, or I'm sure in your country. People stayed home in New Zealand. It's nothing to do with the fact that they were worried that they were going to get beaten up if they walked on the street by Ardern and her clan of alpha females, or whatever the equivalent would be. It wasn't that at all, right? So what is it about us that makes us behave this way? What is it about us that gives these people this power? And I want to stress that locution. We're giving her that power. We gave her that power. She had the power to order us to stay home. Where did that power come from? We gave it to her. How did we do that? How did that happen? Right? How did we make that happen? These are questions that we need to ask if we're going to understand this. Someone just wrote the Crimes Act, and someone just signed the Crimes Act, and we enforce it, and most people, most of the time, obey it. People get sent to prison for disobeying it. Why? Right? Why does it work that way? How does it work that way? What is it about us that makes it possible for society to work that way? Okay. Now, that's the point of the rest of the course, right? My complaint about mainstream jurisprudence is that these are the really interesting philosophical questions about law, and mainstream jurisprudence doesn't want to ask them. Instead, it wants to continue with endless debates about whether Hart was right about this or Dworkin was right about that or whatever. It just wants to argue about itself. But which maybe that would be okay if we'd already answered all the really deep, important philosophical questions, but we haven't answered all the deep, important philosophical questions. So we need to actually move on from the less important questions of mainstream jurisprudence to ask these questions. Now, in order to do this, we have to expand the scope of our inquiry from wider than the law. And I've already done that, because the question I was asking about Ardern could be phrased as a question about law, but it doesn't have to be. It's really more a question of political philosophy, or no, I don't mean political philosophy in the sense of what is just or whatever. I mean a question about political authority, right? What is political authority? How does it exist? How is it created? How is it maintained in our societies? It's a wider question than law. It encompasses law, but it's wider than law. And this actually, incidentally, is something else that I think is wrong about the philosophy of law. The philosophy of law, particularly its positivist school of thought, has been very keen to distinguish law from everything else. This goes right back to the original Austin, the old Austin. He thought one of the key tasks of philosophy of law was to distinguish law from everything else. And I think that's a mistake. That's not an interesting thing to do. The key thing to ask is, what is the nature of law? And it's not right. It's not correct to think that the way to work out the nature of something is to work out how to distinguish it from everything else. That's not it at all. If you want to figure out who I am, what makes Alan tick, the way to do that is not to work out how to distinguish me from everybody else in the world. Right? That's just not it at all. Right? That's an archaic philosophy, which is another criticism I have about the philosophy of law. Actually, the mainstream philosophy of law is it's archaic. It is not familiar with the techniques of modern philosophy, right? It's stuck in the 1950s, basically. But let's just pass over that for now. We don't want to work out how to distinguish law from everything else. We want to understand the place of law in the world. That's the task. That's the philosophical task. Where does law fit in to everything else? That's the question, right? Not what makes law different from everything else, but where does it fit in to everything else? And in particular, when I say everything else, I mean everything else, right? That is, we have a world that's presented to us by the natural sciences, a world of, atoms and quarks and muons and so on. And how does law fit into this world? Right? How does law fit into our general picture of the world? Now, I can't give you a complete theory of that because there's a gap, right, that science hasn't closed yet, and I can't close it. But that's the job of the philosophy of law, to work out how law fits into the rest of the world. Not to just give a theory of law in isolation from everything else, but to work out how law fits into the rest of the world. And that's what I'm going to start doing in the next episode. So I'm going to start doing something that's quite different to what other jurisprudents do, what other people who do philosophy of law do. I'm going to start talking about the mind. Right, that's how I'm going to start. Because I said, why do I do that? Well, because I said there's something about us that makes us able to have law, whereas other intelligent animals can't. Well, what's that something? It's got something to do with what's in here, the mind. It's got something to do with the mind. There's something that our minds can do that chimpanzees and gorillas can't do. So we're going to start investigating the mind, right? And it's only at the end of all of this investigation, right, when we start examining the world, right? It's only at the end of this investigation of the world that we're going to get law, right? So the philosophy of law is the culmination of an examination of our place in the world. Okay, so next episode, I'm going to start talking about the mind. Now, it's important to bear in mind, because there are going to be quite a few episodes coming up that I hope are going to be interesting in themselves, but on the face of it are not going to have anything to do with law. I'm not going to talk about law very much at all, right? But why am I doing that then, if we're talking about the philosophy of law? Well, because we need to understand ourselves in order to understand the role that law is playing in our lives. If we want to understand how we create and maintain law, we've got to understand ourselves, right? Obviously, I'm not going to give a full theory of the human being. I can't possibly do that. But there are certain things about the logical structure of the human mind. And then we're going to talk about language. And then we're going to talk about society. We need to know certain things about the logical structures of these things to work out how it is that we are able to create and maintain law. And then, once we've done that, we're able to use the theory to develop to develop understandings of interesting other things. Like, for example, not only can we understand the creation of societies, we can understand why societies collapse. And we would look at an example of a society that collapsed and talk about why it collapsed, and to be able to understand it in a way that we wouldn't be able to understand if we didn't understand the logical structure of our minds, the logical structure of language, and the logical structure of society. Okay, so that's all by way of, well, it does two things, right? It explains why I'm not enamored of modern jurisprudence, why I think it just takes the law for granted. It takes the law for granted, it takes us for granted, it takes all the important philosophical questions for granted. Right, so it's explanation of why I don't like that stuff, but it's also an explanation of why I'm going to go on to do what I'm going to go on to do. Why I'm going to start talking about what's in here. I'm going to start talking about what's in here because we need to understand what's in here if we're going to understand law, right? So next week, the mind. Next episode, the mind. Thanks very much for watching.